Further hearing in the Volaw Trust Appeal.
Yes, Mr. Sharp.
My lady, my lords, good morning. We were looking yesterday afternoon at AG's reference number 7, and I wonder if we might finish looking at that case now. So, volume...
Remind me where it is.
Of course, it's volume 1, my lord, and we had just...
Tab 10.
Tab 10, thank you. We finished looking at page 1881. You've been considering the extracts from the Canadian case of Thompson that were cited by the English appeal in this case. And I simply wanted to draw the committee's attention to paragraph 59 of this judgment, which is on page 1884. And we can see from that paragraph 59 that the English Court of Appeal accepted or indeed concluded that it was appropriate to make a distinction between statements made and other material that was independent of the making of a statement. And they said that, we say this for the reasons advanced in the judgment of the Thompson newspapers. And they concluded that that was a jurisprudently sound conclusion to reach. So simply wanted to draw the court's attention to this theme, and perhaps I'm labouring it too much, that there is this material distinction between testimony and pre-existing documents and other independent material. And indeed, this wasn't the first time that such a distinction had been made in the English courts. Without wishing to trouble my lady and my lords to turn to the relevant pages, I note that in Tully, Lord Templeman had described the privilege attaching to pre-existing documents to be archaic. The page reference is 1690, paragraph C to D on that page. And in the same case of Tully, Lord Griffiths expressly associated himself with those same comments. Page 1695, paragraph A. And finally, I know you've already been referred to it, but Lawrence Collins, in his dissenting judgment in CPLC, at paragraph 46, page 1970, recognised that there were powerful arguments as to why privilege should not attach to pre-existing documents. And I mention that thread of authority or commentary on the distinction between the two types of evidence, simply to put forward perhaps an alternative narrative to what has been suggested by the appellants. It may be that the real reason that EU case law on documents is few and far between is not because the European Court takes a very strict view about privilege and is only prepared to let in limited examples in driving cases, but because of this considerable difference between the different types of evidence, and that is why one mostly sees testimonial cases going to the European Court. We detected that it may be that the appellants are advancing a slight variation on the arguments contained in their written case. And if we've understood it correctly, we can understand them to be saying that if Article 6 is found to engage with pre-existing documents, then that in itself is sufficient for them to get home on this appeal, regardless of whether or not the use of compulsory powers is still lawful and Article 6 compliant. Insofar as that argument is being advanced, our answer to that is that if the statutory regime is human rights compliant, then that is the end of the appellant's appeal. If the states of Jersey have decided to abrogate the privilege, and they have done so lawfully, and there is no breach of Article 6, then that is the end of the appeal. It may be that it is being said that the decision maker in each case still needs to consider the issue of privilege. If that is the argument now being advanced, then we would respectfully offer two answers. The first answer is that that cannot be right, because the states have removed the privilege in order to facilitate the compulsory power. Therefore, the privilege is no longer a factor for the decision maker to consider in any case. Our second alternative submission is that if we're wrong about our first submission, then in every case, and in particular this case, the decision maker would still arrive at the same conclusion. In a criminal inquiry of this sort, it is to be expected that the suspect or their associates may have due cause to claim privilege. That is why compulsory powers exist and why privilege was abrogated in the first place. We ask rhetorically, why would a public official charged with investigating international crime, be it fraud or tax fraud, reach a different view about whether or not to gather relevant evidence, because he or she may have received an indication of a claim to privilege? That would not be a rational reason to stop the investigation or not to seek the evidence. On the contrary, even if the public official decided to put no particular weight on the claim to privilege, it might at least be said to confirm that the evidence is likely to be probative of some form of criminal activity, which of course it is the public official's duty to investigate. The other submission that was made during the course of yesterday afternoon, as we understood it, is that investigators and prosecutors should have considered in this case providing a use immunity before any documents were provided at all. The fundamental problem with this submission, in our respectful view, is as follows. A public prosecutor providing an immunity from prosecution is a not insignificant step, and the normal process is that the prosecutor fully understands what it is they are granting immunity to. What the appellants are suggesting is that a prosecutor should or might reasonably grant immunity in respect of criminal conduct that has not yet been ascertained or understood. Figuratively speaking, the cart is being put before the horse. The proper way of granting immunity in this sort of case, we submit, is when and only when the documents have been disclosed, perhaps witnesses have been interviewed, and the full extent of any criminality has been properly understood. Only then is the prosecutor, who owes duties not just to the individual providing the documents, but also to the general public, only then is the prosecutor in a proper position to grant immunity if that is appropriate on the facts of a particular case. That is not, I don't suggest that that is a practice or procedure that is special to Jersey. I would respectfully suggest that most senior prosecutors, including the Attorney General of England, would follow the same process. To give an example on a different case, again, I don't ask my lady or my lordships to turn to it, but in volume 1 at page 1670 is the case of Warren versus Attorney General. And the court will see at paragraph 31 that the Attorney General of England declined to give an undertaking to Mr. Warren before he chose, or did in the event chose not to, give evidence in confiscation proceedings in Jersey.
I'll ask you this. As matters currently stand, and for quite a long period of time, trial procedure in the Royal Court in criminal matters in Jersey has been, in relevant respects, very similar to English trial procedure. Was there at some stage an inquisitorial process closer to that which applies in France, for example?
There certainly was in the magistrates' court.
magistrates?
Yes.
Is that still the case, or?
It is not. Forgive me, my lord. I'm trying to remember when there was certainly. It's right that at one stage the Jersey Magistrates Court was very much more similar to the French system. On
in this country.
yes. On the other hand, the Criminal Procedure Law of Jersey of 1861 provided a right to jury trial or election of jury trial in respect of serious offences, which would classically include murder, rape, and other significant offending. So,
The origin of the adversarial system in criminal proceedings. Jury trial
Yes.
combined with an inquisitorial process.
Yes, of course.
I just wonder whether there had ever been an inquisitorial as opposed to an adversarial criminal process.
Not in modern criminal law, my lord.
That's certainly right.
Off the top of my head, I may be able to help my lord over the lunch break.
General basic point. I can understand that if you have a system where the criminal investigation is directed by the judiciary, as in France, the question how documents might be used can arise at an early stage when the juge d'instruction is trying to recover the documents. If you have a system where the court is quite independent of the prosecution, I'm a little puzzled as to why the prosecutor would even be expected to give some sort of guarantee about his behaviour, because at the end of the day, the guarantor of the fairness of the criminal proceedings is going to be the court.
Yes, I agree. What's being proposed, proposal that immunity should be granted at this very early stage before prosecutors even seen a document, is something that's outside my experience. I agree, ultimately it will be for a court to determine what is admissible and fair to be not. And the court is completely independent of the Attorney General, who gathers the evidence in the first instance. May or may not help, my lords, but I wonder if we might look briefly at the supplemental bundle. I wonder if we could look at page 72 of that bundle, please. Page 72 is a sentencing report taken from the Jersey law courts. It relates to the prosecution of a company called Winwood. And one will see at paragraph 1 of the sentencing report, at the top of page 73, that the company was prosecuted for laundering the proceeds of bribery relating to activities in Kenya in respect of contracts that were being awarded to European companies. If one goes forward a couple of pages to page 77, one will see the prosecution sentencing conclusions that were provided to the court in that, for the purposes of that sentencing hearing. And just to assist the court, The prosecutor in Jersey often provides a factual summary of the case to the court in order to assist the court arrive at the right sentence. And one can see in paragraphs 1 to 3 that there is a summary of the money laundering offending that had gone on. And if one goes over the page to page 10, there is a list of...
Paragraph 10.
Paragraph 10, I'm so sorry, thank you. There is a list of companies that made some of the payments to Winwood that form the basis of the money laundering charges. I just wanted to quickly focus on...
Sorry, I don't know that I've got that. Have I?
I'm so sorry. So at page 77, hopefully, is the start of the sentence
Oh, I see.
and conclusions.
Thank you, yeah.
And then paragraph 10 is a list of companies that made the payments to Winwood, which were the subject of the criminal charges in Jersey. And just to give one example, you can see a company listed at 10 paragraph 2, which I'll just call MM for ease of reference. If one goes over the page, please, to page 81, we can see at paragraph 18 of the sentence conclusions a reference to an MM file note. Just to help the court, the process was that the file note was obtained from the company records by use of a compulsory notice. That was step 1. Step 2 is described at paragraph 19, where one of the directors of that company was then spoken to and interviewed, as I mentioned yesterday, by reference to some of these documents that were seized pursuant to compulsion. Their testimony was taken using the compulsory interview procedure, which of course protects them from being prosecuted. Then at the end of that process, the director was used as a prosecution witness in order to form part of the evidence against the company in Jersey. So the decision about whether to treat this person as a witness or as a suspect was only taken after their documents had been obtained and their account had been obtained in the compulsory interview process. And at that stage, then the Jersey prosecution were able to take informed decisions about what was right in terms of going forward with that particular individual. What is not appropriate in my submission is for us to have been required to take decisions about that individual without having seen the evidence that was in the company files. One can see at 18, that is on the face of it, a fairly probative document as to what was going on in this particular case. But I just wanted to use it as an illustration as to the stages in which an investigator might go through before arriving at any final decisions. And that is why we say with respect that the prospect of having to hand out immunity notices is not helpful and certainly not a common practice.
Point that you're discussing, and also the question I put to you a minute ago. If it arises particularly in relation to in this case, the order made for the production of the documents in order for them to be provided to the Norwegian authorities. Because Bowen's position, obviously, is that the order itself is incompatible with Article 6, because the whole purpose, it might be said, is to overbear the will of the company's officers by compelling them to produce evidence which might incriminate them. And so the point in time at which the violation occurs is when the notice is served. If the position if the position is that the use which might be made of those documents would ultimately be controlled by the Norwegian courts, bound by Article 6 as we are. One might query the premise that the effect of the notice is to require documents to be produced which could be used in criminal proceedings against the person served with the notice.
Yes, my lord. There's perhaps two points to make. First of all, we did consider whether to challenge whether or not they had been charged within the meaning of Article 6 at the point they received the compulsory notice, as distinct from when any such evidence was used at trial. The obvious disadvantage for taking that approach is that even if we won on that argument, we might find ourselves back here in a few years' time.
After you were charged.
And we were going to most respectfully invite the board to proceed on the basis that they had charged, even if not necessarily having to decide the point one way or the other. The other thing that we did note in the authorities, that whilst there are certainly some authorities which support the notion that a compulsory notice in itself doesn't equate to a charge within Article 6, there are also more recent authorities which tend to go very much the other way. Just to give my lord an example, perhaps if we look at Bundle 8, page 4395.
I should say I wasn't seeking to question in any way the aptness of the concession made.
No.
The only issue in my mind is, in a case like Saunders, for example, the gravamen of the complaint seems to be the use made of the transcripts at the trial.
Yes.
Perhaps a lack of clarity as to whether what is objectionable is using material compulsorily from the person charged against him in order to convict him of a criminal offence, or in which case ultimately the matter is under the control of the court in a jurisdiction such as this, or whether what's objectionable is the obtaining of the evidence in the first place as part of a criminal investigation, in which case the court's role drops out of the picture perhaps, and you're really focusing on the stage of when the police are investigating.
Certainly there is authority to suggest that even if there are no subsequent proceedings, one can still complain about a violation of one's Article 6 rights. So page 4395 and 4396, my lord.
What if for a subsequent proceeding where the court refuses to allow the document to be admitted?
Well, I see the potential for conflict, but I accept it's not a clear-cut issue. But we would prefer, without resolving it one way or the other, to assume that Volaw have been charged. Because, as I say,
There's a potential for violation at both stages, isn't there?
certainly there are some authorities that certainly speak in that voice. O'Halloran says quite explicitly that Article 6 of the Convention can be applicable to cases of compulsion to give evidence, even in the absence of any other proceedings, or where an applicant is acquitted in the underlying proceedings.
Well, that's perhaps a different question.
Yes, but I accept that it's not clear. It's not clear at all. But certainly, from Jersey's point of view, or sorry, from the public authorities in Jersey's point of view, we'd welcome clarity on the issue, because it's important for the efficient operation of statutory regimes that are important for Jersey's international relationships and obligations. My Lady, my Lords, I was asked, or I believe both parties were asked yesterday, about whether or not there was any Jersey authority relating to Article 3 and the obligation of the Jersey courts to follow European authority. I believe my learned friend has found some Jersey authority that speaks about the duty to follow European court cases, albeit it doesn't go into great masses of detail. But can I say, just to help, we accept that the Jersey court would almost certainly follow the English cases in this area. So if there was a clear and constant line of authority, I would accept that the Jersey court would follow it. There may be, there are examples, of course, where the English courts have not followed the convention or have departed to some degree. I have in mind Horncastle, and I'm sure the Jersey court would have had that authority in mind too if it felt it appropriate. So I don't see that there's any material difference between how a Jersey court would approach the issue and how a English court does, and has been perhaps better recorded in the case law. I promised yesterday that I would return to the history of the matter, and in particular the fraud notice, and I wonder if I might do that now. I don't think there's any great dispute about the history of the fraud notice. It started life as a result of a mutual legal assistance request from Norway, seeking assistance for their prosecution. And so its original purpose was, of course, to provide documents to Norway. It's also right that after Norway's need for those documents had fallen away, the Attorney General of Jersey communicated in January 2017 to Volaw that he wished to maintain the notice for the purposes of a local criminal investigation, his own investigation in Jersey. The blunt reality might be that the prosecution authorities in Jersey should have commenced an investigation, their own investigation, I mean, before they did. The Norwegian court's decision in the first instance in the Larsen matter, which is in the record of proceedings at volume 4. I don't ask the court to turn to it, but the page references are 1213 and 1230. They feature some of the directors appointed by Volaw to manage Mr. Larsen's companies, giving evidence on oath that they really had no idea what their duties were, or what the companies were doing, despite having been appointed a director of that company. The court also found that there was evidence of the backdating of commercial documents. The court found that that went on or was more prevalent as a practice than the Volaw officials who gave evidence to the court were prepared to admit. And of course, all of that says nothing about the overall findings of significant tax evasion being orchestrated through offshore trust and company structures. So even allowing for the appeal, a successful appeal that followed, there were ample grounds, and indeed it was appropriate for the Attorney General to consider his own investigation into this matter. By way of background, in May 2016, the Council of Europe, a body called Moneyval, published a report on Jersey. The Moneyval body reviews money laundering systems of different jurisdictions around Europe, and although its report into Jersey was broadly positive, it made specific recommendations that there should be more prosecutions and investigations in respect of financial crime, and also specifically stated that more resource should be put into considering whether cases that start life as a mutual legal assistance request should in turn trigger a local investigation. Since that report, the Attorney General of Jersey's policy has been to focus more on this particular area, to review mutual legal assistance with greater care, and one result of this new initiative is the decision to open an investigation into the Volaw case. The parties agree that the Attorney General's decision in January 2017 is not an issue before this court. Indeed, it's perhaps worth noting in passing at least that nothing was said by Volaw to the Attorney General between January 2017, well, nothing was said at all until preparations for this hearing began. So for whatever reason, Volaw have waited until this hearing, a year and a half or more later, before saying anything at all about it. But as I say, both parties accept that this is not an issue that need trouble this court today.
Can I just ask you, the notice itself, under the heading Person Under Investigation, names Mr. Larson. Are we to take it that in effect, the persons under investigation are now the appellants?
Yes, yes, my lord. There was a communication made on the 26th of January 2017 to that effect. Sorry, forgive me, my lord. It may have been an error on our part to agree the facts rather than put the communication in the bundle. I believe, from memory, the email speaks of Volaw, that the company being the investigation, as distinct from all the various companies that are listed as appellants in this appeal. Pleases the court, may I please turn briefly to the argument about VIRES and the tier regulations. It's common ground that the manner in which regulations are passed and brought into law in Jersey is slightly different to the United Kingdom, in the sense that the states of Jersey as a whole gets to vote on those regulations. Not in the sense that an English court might understand that. Or no, precisely. The other feature I wish to draw to the court's attention is this. The OECD model and commentary is just that. It's a model and commentary that was designed to be pushed out on a global basis to all sorts of different jurisdictions who had, no doubt, all sorts of varying rules and procedures. In my submission, Jersey had to pass laws that were relevant to its jurisdiction and relevant to its laws and relevant in order to ensure that there was a robust system that was going to meet international standards and obligations. And the relevant, perhaps one of the relevant background pieces of law in respect of Jersey is that money laundering, the proceeds of tax evasion, even prior to the tier's introduction, had been a criminal offence since 1st of July 1999. And I don't ask the court to turn to the relevant case, but in Bundle 11, at page 5581, one will find the case of Peter Michel, who was an accountant in Jersey who was prosecuted for various money laundering charges, which primarily related to the laundering of the proceeds of tax evasion. So when the states came to pass the 2004 law and, of course, then the 2008 regulations, the law in Jersey was that any financial services provider who was found to have laundered the proceeds of tax evasion would have committed a criminal offence. Therefore, as a matter of common sense, if one is going to provide assistance pursuant to the tier legislation in which criminal tax matters are to be pursued and facilitated, and financial services providers are going to be the subject of those requests because their client in Norway or wherever it is may have committed tax evasion. Fairly obvious that sooner or later a financial services provider was going to claim privilege. And that is why there was a need to abrogate the privilege otherwise every trust company in Jersey would have been able to say, claiming privilege, we're not disclosing documents about our client. And that is a far more relevant background in my submission to the tier and the necessary ambit of it, whether one picks the word necessary or expedient. My submission doesn't greatly matter.
It's not in doubt that the validity of regulations depends on their being made in compliance with the 1991 law.
2004 law, my lord.
Yes, of course. Yes, the 2004 law. Yes.
No, I believe that's common ground between the parties. So it's all a question. So as I understand it, the principal question is what was necessary and expedient. My submission is that if you look at the realities as to the sort of information that was going to be provided against the backdrop of Jersey's criminal law, it was either necessary and at the very least expedient to abrogate privilege to ensure that there were no difficulties in obtaining documents from financial services providers who may have felt extremely uncomfortable as and when their client is the subject of a criminal inquiry into tax evasion. It would be surprising if anything else had happened. Because if it was otherwise, one might see this sort of claim being made routinely with the event of the total frustration of the scheme. And ultimately, the appellant's submission appears to boil down to the fact that there is some commentary in the OECD which speaks about the varying laws of privilege in different states. And as I say, the problem with that, leaving aside the fact that even the appellants accept it's not legally accurate, is that commentary is just commentary, and it doesn't reflect the legal realities on the ground in Jersey, which is what the states of Jersey were having to consider and deal with and pass appropriate legislation for. May I deal briefly with a different topic? It doesn't actually concern an issue that needs to be determined on the appeal, but I believe it was said yesterday afternoon that the International Cooperation Law of 2001 provided privileges, certain privileges, but I wanted to be clear about our position on that, which is that the 2001 law has two different processes. Process one is that the Attorney General can serve a notice and obtain documents in a not dissimilar way to the fraud law. And process two is that a witness can be required to give evidence in a Jersey court as part of the facilitation of a trial that may be going on in a different jurisdiction. Whilst I accept, of course, that in respect of that process, the second process involving a trial, we accept that the witness is granted certain privileges. We don't accept that the first process, i.e. just the obtaining of documents, in any way maintains any privilege. But as I say, I don't see it as an issue in the case, but I just wanted to record our disagreement with the issue in case it was said that my silence was going to constitute agreement. My lady, my lords, can I touch briefly on Jersey customary law to the extent that I need? As I understand the issues in the case, the extent and precise ambit of Jersey customary law only comes into issue if the committee is not with me on the vires of the regulations. Because if the court finds that there is vires in the regulations, then it doesn't matter what the scope of the Jersey customary law privilege is, because it has been abrogated and we're just straight back to the Article 6 point that we discussed yesterday afternoon. But I simply wanted to emphasise that from our point of view, Commissioner Belloff was entitled at first instance to define the Jersey customary law as he saw it to be by reference to the laws of Jersey. And we strongly disagree with certainly what's said in the written case, that he was obligated to follow House of Lords authority in respect of English common law. That's not to say that a Jersey court does not treat the decisions of the House of Lords and indeed this committee with the utmost respect, and they are often highly persuasive and are followed. But there are examples in Jersey customary law whereby, on occasion, the Jersey court has not followed the English common law on a particular point, even if, in general terms, the English law has heavily influenced the area of Jersey law that is under consideration. Yes, they do.
Stage aspects of insolvency law. It's that sort of area, isn't it?
Well, they have also covered broader areas of criminal law. So, for example, the Jersey Court of Appeal has held that in terms of considering the admissibility of evidence, it wasn't obliged to follow English House of Lords authority in Sang on that point. So that's the Jersey case of Clarkin. The Jersey Court in Criminal Law has also, for example, in the Warren proceedings, the Jersey Court of Appeal allowed in anonymous witness evidence. Not long after the House of Lords in Davis had said that the English common law simply wouldn't allow any form of anonymous evidence. Further example might be that the Jersey Court declined to follow House of Lords authority in respect of whether a Moravian injunction could be granted as a freestanding injunction when no substantive proceedings were to take place in Jersey. So in other words, in aid of foreign overseas proceedings. Exactly. One often sees, what one could say about the pattern is one often sees that the House of Lords, a decision reaches the House of Lords in England. The House of Lords feel that the law is so well established, perhaps as in Tully, where despite describing the privilege as archaic, it was still felt that it covered pre-existing documents in the civil proceedings. So what normally happens is the House of Lords will reach that decision, and very often Parliament will perhaps make a change to the law. And what tends to happen in the Jersey courts is that they may very well follow a different path because there is a greater degree of flexibility and they are not strictly bound by a House of Lords decision. And the Jersey customary law in general terms is a more flexible animal than the common law and the stricter rules of precedent that occur in this jurisdiction. So the position is that that Commissioner Beloff had considerably more flexibility sitting as a commissioner in Jersey than he would have done had he been sitting as a High Court judge in London. And the upshot of that is that he was entitled to consider whether it was appropriate to introduce or find that Jersey customary law recognised a privilege against self-incrimination in respect of pre-existing documents at a time when it would appear that whatever the position of English common law, there was no enthusiasm for such a proposition in England, to the extent that the House of Lords judges had disapproved of the concept. Lawrence Collins had disapproved, or certainly accepted there were strong arguments in favour of no privilege, and a whole host of English Court of Appeal decisions apparently recognising the force of a distinction between pre-existing documents and testimonial evidence.
far as there is a difference between Jersey and England, these are not really propositions of Jersey customary law. They are really simply decisions that conditions in Jersey do not justify the same approach. And I mean, given that we are sitting as a Jersey court, it seemed to me that unless there is some pertinent difference or some rule of customary law properly so called to a different effect, effectively we're likely to reach the same conclusion as we would if we were sitting as a court of family of the
Well, I understand that. Thank you for that indication, my lord. Perhaps I can just take you to an example of a case. Perhaps if we look at bundle 11, please, behind tab 117, which is page 5495. The decision of the Royal Court in Knight and Thackeray. If one looks at the heading, it's quite helpful to look at the heading on the first page at 5495 and just the paragraph above held at the bottom. Essentially, the case was about the fact that at the time of the judgment in 1997, Jersey law had distinguished on occupier's liability in the sense it differentiated between whether someone was an invitee, a licensee, or a trespasser. But that had been the case for quite some time. But around the Commonwealth, those distinctions had been had effectively been abandoned on the basis there was no good reason to maintain them and they were outmoded. So the Royal Court was invited to redefine Jersey law on the basis that what had been the law simply wasn't appropriate in a modern age. That is, in effect, what the bailiff did in this case.
There's a Court of Appeal decision, I think,
yes, there was a
in
court
Jersey on exactly the same point.
Yes, there's a Court of Appeal decision in Guernsey which was prayed in aid by the parties appearing before the court. But if one looks forward, please, to page 5503. Onwards.
5583.
5503. 03, thank you.
35 onwards.
That's right, my lord. So there's a sentence that begins, in our judgment. There's no justifiable reason for perpetuating outmoded distinctions which have been swept away by one means or another in every Commonwealth jurisdiction, law of which we've been referred. So without waiting for any Court of Appeal decision, or without waiting for anything else to happen, the Royal Court's customary law evolved.
Fairly customary law. It was modifying the position laid down.
That may,
Statute which changed it in England.
yes,
Didn't exist.
and it may well have, and I accept that these principles originate from English common law, but they are often brought into what is still Jersey customary law, even if, and that's what it is, even if it's
There's a difference between evolving Jersey customary law and simply developing the common law in a way that is different. We're obviously right to say that the common law in Jersey does not have to be exactly the same as it does in England. And the problem in this case was that in England, the common law was in a state of arrested development because there'd been statutes that took over the the job.
Well, I see that. I mean, I'm simply using it as an example to show that the Royal Court can move with the times rather than having to follow any particular precedent.
The precise boundary between what one calls Jersey common law and Jersey customary law may not matter. I think in the context of Guernsey, I think this was discussed by the board in A&R earlier this year. But in your experience, is a clear line drawn between what one calls Jersey common law and Jersey customary law? Yes, that's what I thought you said.
I accept that there probably are some Jersey judgments that mention the common law of Jersey.
Yes.
So can I say with that qualification?
That's a little unrealistic, because
But-
if in a particular area of law, the law of tort is almost entirely originates in English law. Say that, I mean, to rechristen a common law proposition adopted in Jersey.
I can only speak to the constitutional origins of Jersey law as I understand them to be, but I accept entirely that it draws widely from a wide range of sources, and it, on occasion, borrows very heavily from common law jurisdictions. And I accept all of that, of course, but it's also right that that it is still a more flexible creature.
Well, if you refer to it as judge-made law rather than customary law, then would that solve your problem?
Quite very possibly. May I just show you the court with just one more example? If we change bundles, and I'm sorry to make you jump about, but if we look behind tab 111, we should hopefully have the esteem judgment. Sorry, 112 in fact. So this is the judgment of Deputy Bailiff Burt, as he then was, who obviously went on to become bailiff and is now sitting in the Court of Appeal in Cayman.
Could you please give me the page?
Yes, I'm so sorry. The relevant page is page 5209, and the relevant paragraph is 154. This was the court considering Jersey law, in which it was considering claims and restitution, and how to define that in Jersey law. And of course it was doing so by reference to English principles. But you'll see at 154 that the court wasn't minded to accept the current position in England at that time because it described it as unsatisfactory. And I think one goes on to 157. One reads through to 157. One gets to a sentence that says, in other words, the state of mind required for a knowing receipt claim under English law is not required in Jersey. So the reason, in other words, what happens in this judgment, or what the Deputy Bailiff Burt did in this judgment, was to look at the English law on knowing receipt, identify in the Jersey court's view difficulties with this area, and then define the Jersey law in a different way.
Yes, but your point is that the judges in Jersey have the right to take what they want, as it were, out of English law. And if there are examples of English common law where the courts have expressed concerns, you're fully entitled to say, well, we're not adopting that.
Yes, particularly in circumstances where there seems to be a universal expression of concern.
Yes. So you're a small jurisdiction using comparative law and adapting what you see to your circumstances.
Yes, that's exactly precisely it. Thank you, my lord. May I just trouble the court with just one more reference that's in volume 15. This is a judgment given by Commissioner Page rather than a Jersey resident judge. That's the only reason I mention it. But at page 6928, volume 15.
Yeah.
This is from an English commissioner. You'll see that in this judgment, the Royal Court agrees with what the Deputy Bailiff said in his deed, and then said this: we see no merit whatsoever in burdening Jersey's jurisprudence with a distinction that serves no useful function, that only makes for complexity and uncertainty, and that has its roots in a legal system which, for historical reasons, has resulted in competing concepts devised by judges with different philosophical views and jurisprudential backgrounds for which there is no equivalent tradition in Jersey. And on it goes. So again, just another example of the court being conscious and aware it doesn't have to follow English law in every aspect, even if it may very well follow it in most. As I say, my submission is, why would a Jersey court want to follow something that the House of Lords has described as archaic? If it had a choice about the matter, I respectfully suggest that most judges would not follow. But my lady, my lords, those are my submissions on Jersey customary law. Unless the court has any questions in particular, those are my submissions.
Well, I have a question. Your basic submission is, as I understand it, that a distinction is to be drawn between, on the one hand, evidence which a defendant is compelled to generate by, for example, answering questions where the answers might be inculpatory, and on the other hand, evidence which is in existence, which may be equally inculpatory, but does not require contemporaneous generation. And I've been wondering, what is I suppose, the philosophical basis for the distinction between the two? Both give an historical account, both involve, at least potentially, an overbearing of the will of the person being required to produce the evidence. Why should that distinction exist?
At least two reasons. First reason is that the creation of testimony only occurs when the person is subject to an investigation and facing possible criminal charge. So it is not a creation of something in the ordinary course of the day. It is a creation of something for a particular purpose to be used by the state against that person.
It's where the relevant evidence was created.
I see.
Yes, but why should that make a difference?
Two reasons. One, go back to the example I was about to give. The note, the file note I showed you for the company, that was dated, I forget exactly, but something like 15 or 20 years before the notice was ever served. But why it makes a difference is because if you are a suspect and you are asked to answer questions in a police station, to take an obvious example, you are suddenly under pressure, and all the underlying principles that Lord Mustell sets out in Ex parte Smith come into play. That's why it makes a difference. I suppose coming on to my second point, which is linked to the first, which is this, the file note, its relevance and probative value is in no way come back to the person who is under suspicion. It's independent of them, and its relevance and probative value can be assessed by a court without the court having to worry about its link to the person who is charged. It's the independence from the individual which makes such a difference.
So really you're focusing on the degree of the interference with the person's autonomy being greater where the person is compelled to testify effectively, on the one hand, as being required to hand over something which has an existence independent of any exercise of volition on his part.
Exercise of any legal obligations.
Might it also, the answer vary according to the purpose for which you're asking the question? And if the question is, was there a fair trial, or could there now be a fair trial? The reason why you're looking at pre-existing documents may not differ much from why you're looking at statements, Lord Kerr's point. But on the other hand, it may be that there is of an unfair trial, or that the trial was perfectly fair, notwithstanding the use of these pre-existing documents. So if that's the purpose of asking what the privilege was all about, whether it existed, then it depends on what happens or might happen at a trial.
Yes, I accept, of course it does. Though one has to accept that if someone provides testimonial answers at the start of a case, that may very well cause the state to be able to gather evidence from other sources which will potentially strengthen the case. So what you say at the start of an investigation might matter quite a great deal.
Well, it would lead the prosecution on to further inquiries, but nonetheless, he would have to be convicted, if the statement was not admissible, see Section 2.7, on the basis of the further evidence. That would have to stand on its own 2 feet.
I agree.
So the test of fair trial would then be passed.
No, I agree in those circumstances, yes.
Well, I suppose the distinction may not. In the case of Jallow, it's a reminder that these distinctions are not hard and fast. And if you were to torture somebody into handing over documents, for example, that would plainly be as objectionable as forcibly administering an emetic for someone to be compelled to produce the drugs that he'd swallowed.
I entirely accept that. I'm prefacing my submissions on the assumption that there is a lawful exercise of the relevant powers with no special features or extreme behaviour.
Yeah.
Yes, and you explain a case such as Funke as being an example of extreme behaviour rather than as being a typical case.
That line of authority, starting with Funke and JB, where there's this persistent, repetitive or incremental fining of someone, is not the purpose of the criminal sanctions in the Jersey legislation, or for that matter, the English legislation. And it just simply wouldn't happen.
Well, they're all instances of oppression, and in fact, Jallow can be brought into that as well.
Jallow is such an extreme case.
Yeah, but they're all examples of the state behaving oppressively to the individual. Or in an underhand.
I mean, the fining cases feel like the state is in some sort of attritional war against the individual. It's, I think, how I put it in my written submissions, and that's how it comes across.
It seems that the Strasbourg court may have shoehorned it into PSI, but you'd say, as I understand your submission, that it's a breach of Article 6 in terms of a fair trial, but you'd characterise it as an abuse of process rather than something that falls very directly within PSI.
I have to say that's how it feels.
Yes.
Very much. I mean, the thing in Volaw, even before they got onto PSI, they said the breach
Well, they
of
said it was Article 3 violation as well.
so they could have stopped there. And said that's
yeah,
enough.
Because it's noticeable that those cases aren't mentioned in Ibrahim, which may suggest they're outliers.
Yes, I accept that. I mean, they are very unusual cases, I have to say, from a Jersey legal perspective, accepting that clearly those countries had those procedures in place.
It would follow from this discussion that you could have a case, since every case will turn on its facts, where the use of pre-existing documents could amount to a violation of the guarantee of a fair trial. That was a Saunders-type situation. Use of transcripts.
Well, that was the use. Well, that was the use of testimony. I mean, I accept completely that the minute you get into the using of testimony that's been created, once the person's been placed under investigation, that is very different. I wouldn't accept that pre-existing documents are going to breach Article 6 unless there's some particular feature about the case that we've just been discussing. Because absent that special feature, it's very difficult to see.
It's not an absolute privilege anyway, and it's a... Yep.
Have to be something fairly extreme for a pre-existing document not to go into a court, having regard to the fact that even unlawful searches, absent elements of bad faith, the evidence would still normally be admissible.
So something which constituted a denial of the very essence of the right to a fair trial.
Where essence means precisely, but yes, my lady.
It's probably one of those things that you know when you see it.
That's why I said, I entirely agree, that's why my submission was if Volaw felt like an abusive process, because it's one of those things when you see it, that's how you call it. My lady.
Well, what we may need to wrestle with is that in Ibrahim, on the one hand, the court begins paragraph 267 by telling us that the privilege protects against the obtaining of evidence by means of coercion or oppression. But then the end of 269 tells us that what's crucial is in this context is the use to which the evidence obtained is put in the course of the criminal trial.
It's difficult to grapple with that, and without turning it up again, the Belgium case about the unlawful search, that evidence was used to convict someone for 5 years, but that doesn't get a mention in the analysis of whether or not the essence has been destroyed or not, which is a very significant omission on one view.
For which the evidence is used, they must have meant the purpose for which it was intended to be used in the context of a complaint about the original.
But the other way, perhaps, it might be that you test whether the obtaining of the evidence was a violation by reference to how it's used in the trial. Yes. So it's not only got to be an oppressive obtaining, in this case, Ibrahim, the administration of the wrong form of caution, but then you look to see how the prosecution used it at the trial, which was here to, which in that case was to secure the conviction.
Yes, and well, Ibrahim was about these use of these safety interviews, so the conduct of a very swift interview without the solicitor being present.
That's right.
For public safety reasons. Of course, during the course of those interviews, the accounts given were damaging to the suspects, and of course was that those interviews were deployed in the trial. And it may be that, so on the one hand, that was a significant piece of evidence against the accused. On the other hand, all the other evidence, including the fact they'd marked the chemicals they'd been boiling up to a certain percentage, was also so much more probative and damning. Probably made no difference.
Yes, the failure to comply with the guarantees about legal advice was held to be justified. That was the first issue.
That's right. Apart from some technical issues about the precise wording of the court. So I don't wish to not say they're unimportant, but in the grand scheme of things, it was a relatively small detail, and I believe the court found that it made no difference to the suspect's understanding of what it was they were facing in that interview.
So it's a pragmatic test at the end of the day.
Yes.
I understand that where Ibrahim in paragraph 269 refers to use, it's referring back to the point that was made in Saunders that evidence which was not ex facie incriminating might nevertheless later be used in a manner to incriminate.
Yes, I accept that entirely.
Yes.
So even what is on the face of it, an innocent explanation,
Yes.
and you get to trial and it turns out that there's a different story being put forward,
Yes.
you might then use that to cross-examine on credibility.
So there may be cases where the subsequent use is relevant. There may be other cases where you don't need to consider subsequent use because it's ex facie incriminating. Yeah.
Thank you very much indeed, Mr. Sharp.
Very much, Madam.
Mr. Byrne.
Lady, my lords, could I just start by dealing with the so-called factual matrix as it's now developed in the light of my learned friend's submissions? You've been referred to the decision taken by the Attorney General on the 26th of January 2017 to maintain the 1991 law notice. Now, at the moment, the only evidence you have of that is in the SFI, the Statement of Facts and Issues, at paragraph 62. But my learned friend has represented the email that was sent as saying something that it did not say. And therefore, reluctantly, it seems to me that the only way of remedying that is by showing your lordships a copy of the email and the letter which precipitated it. And with your lordship's leave, therefore, I will just arrange for copies of that to be passed to your lordships and to your ladyship. Your lordships and your ladyship consider it helpful. The particular passage of most relevance has been highlighted. Just so I can explain why this wasn't before you, we had been intending to put a further affidavit before the board just to set out the relevant documents for the board, and I was persuaded by my learned friend that we could do it just by way of explanation in the SFI, but it seems that we do need this document to go before you. But the point that my learned friend made was that he, and indeed this was from Mr. Sharp, this email, is that he had indicated that the person under investigation was to be changed from Mr. Berg Larsen, who was the name on the existing 1991 law notice, and it was now to be Volaw. You will see from the highlighted passage that in fact there's no indication in that email of who is to be the person under investigation. It simply says the Attorney General of Jersey has determined to open his own investigation into this case and therefore maintains the article notice in order to progress his inquiry. You've got, my lords, a copy of the email which precipitated that response, which was from those instructing me asking for the 1991 law notice to be withdrawn. Now, my learned friend makes the point that no steps were taken to challenge this decision after it was made. But of course, there's actually, in some respects, been no decision taken. There's been no supplementary notice issued. We don't know who the person under investigation is. We don't know what the grounds for issuing a supplementary notice are. And so the process that is triggered under the 1991 law has not been recommenced. There is no possibility, if one looks at the investigation of fraud law, my lords, my lady, which is in volume 1 of your authorities bundles, if we just go back to that, and we can see what the process is supposed to be.
Give me the page for that, please.
Well, it starts at page 1595.
Is this a point that
for
actually
our
matters?
purposes.
What's the relevance of this point? I mean, suppose that you're right. All it means is that if the Attorney General succeeds on the other point, you'll get a notice in which the word Volaw appears.
Well,
And if he's right on the other points, you have to comply with it.
well, what it means, my lords, is one of the questions that you're going to have to decide is whether to quash the notice, if you find for me on the issues of law, or to find that the notice is a proportionate restriction or interference with Article 6. And my point is that insofar as it is now being maintained, effectively that is the legal that's the factual basis upon which you are being asked to find that there has been a proportionate interference with Article 6. So that's, my lord, the relevance of it. I don't want to make any more of a point about it.
I mean, obviously, this appeal isn't concerned with any challenge to the decision that's intimated by the email.
No, it only comes up if you find for us that the approach that was taken by the Court of Appeal, which echoed that of the Commissioner, that Article 6 had no part to play, was wrong. And you then have to consider what steps the board should take. And it is my submission, and it was in our case, that effectively you must allow the appeal in those circumstances, should indicate what factors are relevant, should quash the notice, because of course it was made on an erroneous basis as well. And if the Attorney General wishes to pursue this matter, then he will need to go back, start again from scratch on the basis of the new evidential basis as it then exists. That's the submission, my lord. I don't want to take your time up with it in any more detail than that. My lords, my lady, the reference to the human rights law and whether the law is the same in Jersey and in as it is in the United Kingdom. My learned junior, Mr. Leith, has been very industrious and has found 2 cases where this question has been considered. There are copies available for your lordships. I probably don't need to take you to very much, but suffice to say it's acknowledged by my learned friend that the Uller approach of clear and constant line of authority, as that was interpreted in Horncastle, and as it's since been interpreted in, for example, Dee and the Metropolitan Police Commissioner and Kennedy, is the correct one. So if I just give your lordships the references, I won't take you to the paragraphs, but in the first case, that's the Roberts case, Attorney General against Roberts, that's paragraph 13. And in the second judgment, which is the Gosselin judgment, it's in fact paragraph 40, citing a report by Lord Carswell. Perhaps I will just ask your lordships and your ladyship to look at that one. That's the thicker of the 2 documents. Gosselin, paragraph 40, where bailiff cited the report by Lord Carswell to a number of matters, but it's the third paragraph of the extract that he cites, which begins, "This is termed objective bias. The test in European human rights jurisprudence is phrased slightly differently, that the arrangements must provide sufficient guarantees to exclude any legitimate doubt as to the tribunal's impartiality. It is now well established, both in UK domestic law and in the jurisprudence of the European Court, that objective bias will invalidate a judicial decision. The same will follow in the law of Jersey, as the Royal Court is bound by Article 3 of the Human Rights Law, Jersey, to take account of decisions of the ECHR." Now, I would only respectfully submit that bound is probably putting it a little highly, but it is the clear and constant line of authority approach which the board should take.
Is the report doing no more than stating what Article 3 of the law says?
Well, actually, Article 3 says, well, it's bound to have regard. It's bound to have regard, yes.
This tells us nothing.
Those are the authorities on the Human Rights Jersey law, but it's not an issue between us. Can you complain of a violation at the time of the request is a matter which has come up during the course of your Lordship's and your Ladyship's questioning of my learned friend. And I referred you yesterday to the case of Way, but I didn't take you to it. And perhaps if I might take you to it briefly, it's at volume 8, tab 89, and it begins the passage which I'd like to take you to at page 4500, 4500. Bottom of the page, paragraph 41, a perusal of the court's case law shows that there are two types of case in which it found violations of the right to silence and the privilege against self-incrimination. First, there are cases relating to the use of compulsion for the purpose of obtaining information which might incriminate the person concerned in pending or anticipated criminal proceedings against him, or in other words, in respect of an offence with which that person has been charged within the autonomous meaning of Article 6. Secondly, there are cases concerning the use of incriminating information compulsorily obtained outside the context of criminal proceedings in a subsequent criminal prosecution. So it is possible, and indeed has been found on many occasions, for there to be a violation of Article 6, the privilege, even though there's not any subsequent criminal trial, let alone the evidence is not used at that criminal trial. And I mentioned that it was common ground between us that the Green Environmental Industries decision of the House of Lords was wrong insofar as it was held that it's only at the trial stage that Article 6 privilege comes into play. And I did take your Lordships yesterday to the decision of the European Court of Human Rights in Shannon, which followed the decision in Green Environmental Industries, when the government argued on the basis of Green Environmental Industries that in fact Article 6 privilege only arose at the time of trial, and that submission was specifically rejected. And just for your Lordships and your Ladyships note, that was volume 8, tab 87, and it's page 4444, paragraphs 27 and paragraphs 33 to 35.
3 to 35. Thank you.
My Lords, the two key issues before the board that, at least in terms of the arguments that have been presented orally, are firstly whether the privilege under Article 6 is applicable at all, that's to say whether it applies to documents or not, and the second is whether there's been a breach of Article 6, in particular by virtue of the absence of any use immunity being offered or being introduced by the courts when the notices were challenged. My Lords, I outlined yesterday the 4 reasons why we respectfully submit the courts below were wrong, and why the courts in the Attorney General's reference case and the authorities that followed it were wrong. to conclude that Article 6 does not apply at all to pre-existing documents. There were 4 reasons. The first was that the Strasbourg Court doesn't draw this testimonial, non-testimonial distinction. It's concerned with the nature or degree of coercion rather than with the nature of the underlying material. And in that regard, it's important to stress, and this goes back to the point I was making in the context of the Way judgment, a breach of the privilege against self-incrimination under Article 6 is itself the breach of Article 6. So there's no possibility that if there is a breach of the privilege, that one can then go on to consider whether the trial was a fair one or not in any event. That is in and of itself a breach of a fundamental defence right, and that leads to the breach of Article 6. Secondly, we argued that it has now been shown that Funke and France has been followed consistently and applied consistently by the courts, by the Strasbourg Court. And therefore, to the extent that the judgments, in particular in the Attorney General's reference case, concluded that Funke must have somehow been departed from, is an error of law. And indeed that there is a clear and constant line of authority when one looks at these authorities in procession, in succession, as I've taken your lordships and your ladyship to them, that in fact the Ulla principle should be applied and there's no reason to reach any other conclusion. Thirdly, we argued that the reliance upon the Canadian and US authorities, to which reference has been made in a number of the judgments. You were taken this morning to the Attorney General's reference case where the Thompson case was referred to, and indeed in the CPLC and P case, Lord Justice Lawrence Collins, as he then was, referred to those same passages. And it's our submission that, while understandable, was another error of law in the context of Article 6. Firstly, because para 110 of Jallow, the court does not make a testimonial, non-testimonial distinction at all. But secondly, because it doesn't provide authority for the proposition that, those Canadian authorities and American authorities do not provide support for the proposition that Article 6, that the privilege doesn't apply to documents. Because in the Thompson case, what the Canadian court said was that, and this comes to my Lord Kerr's question about what is the philosophical distinction between documents and statements. What the court held was that if the material could be obtained independently of the use of compulsion, then there was nothing unfair about using it in a trial against that individual. And that is the philosophical distinction. If it would have been possible to obtain that information anyway, there's nothing unfair about confronting the individual with that information at a criminal trial. However, if that material cannot be obtained by other means, then it is a breach of the privilege against self-incrimination to use it in just the same way as it is a breach to compel them to answer questions.
So applying that to the Windward memo, that couldn't be obtained except by asking the person who'd created it. So you would say that the privilege must attach to that.
The privilege would attach, and the Canadian courts would say that that is a breach of the privilege and a breach of one of the fundamental principles of justice under Section 7 of the Charter. And the Canadian Supreme Court has since developed this principle. And in a 9-member panel of the Supreme Court, in a case called Stillman, have distilled these principles to a single page. And for that reason, I don't feel any compunction about taking your lordships to it. It's at volume 14, tab 149. And the page I'd like to take you to is at 6694. I mentioned yesterday, my lords, my lady, that what the Canadian court has done is to take a relatively broad brush approach to the concept of privilege and to include within it material which even the European Court of Human Rights would not include, such as DNA evidence, and Stillman is a DNA case. And what the court does is they approach it by asking, is it conscriptive evidence? Has it been obtained by coercion from the individual? So that's the first stage, paragraph 1 on page 6694. Classify the evidence as conscriptive or non-conscriptive based upon the manner in which it was obtained. If it's non-conscriptive, its admission will not render the trial unfair, and the court will proceed to consider the seriousness of the breach and the effect of exclusion on the repute of the administration of justice. But it doesn't involve the privilege. Secondly, if the evidence is conscriptive and the Crown fails to demonstrate on a balance of probabilities that the evidence would have been discovered by alternative non-conscriptive means, then its admission will render the trial unfair. Now, I rather rush that because that's the critical point. If it's conscriptive, then the Crown has to demonstrate on a balance of probabilities that it could have obtained the information in some other way.
That it would have.
That it would have done. And if it can't do that, then the evidence cannot be admitted. There's no balancing exercise in those circumstances. That will be a breach of the privilege. The court, as a general rule, will exclude the evidence without considering the seriousness of the breach or the effect of exclusion on the repute of the administration of justice. This must be the result, since an unfair trial would necessarily bring the administration of justice into disrepute. But the point is that the reliance upon such material is itself what makes it unfair. And then thirdly, if the evidence is found to be conscriptive and the Crown demonstrates on a balance of probabilities that it would have been discovered by alternative non-conscriptive means, then its admission will generally not render the trial unfair. However, the seriousness of the breach and effective exclusion will have to be considered. Now, my lords, my lady, you will not find in any of the UK authorities or the Strasbourg authorities this concept of whether the material could be obtained by some other means. But what's very important to bear in mind is that by looking at the Canadian authorities, you are not lulled, as I'm afraid the judges in the cases to which you've been referred were, into a mistaken understanding of how the Canadian courts approach these things. And in fact, the Canadian courts have a broader attitude, a broader approach to privilege than do even the Strasbourg court. My lords, we also submitted yesterday that the fourth reason why there was an error of approach in those judgments which were followed by the Commissioner and the Court of Appeal in the present case was because they adopted too narrow a rationale for the privilege, because they limited their consideration to the purpose of avoiding coerced confessions. And it was our submission, and remains our submission, that if you limit the consideration of the rationale to that purpose, then of course that is a philosophical reason for excluding documents from from being covered by the privilege. But that is not what the Strasbourg court, and indeed that is not what the UK courts in other conceptions consider the purpose of the privilege to be.
It's about, as I understand it, which turns partly on the Article 8 of the Canadian Charter and partly on the rules about the permissible modes of searching an accused in a police station under the criminal code. Is that right?
That's right, yes. I'm not
That makes
suggesting
its general application a matter of some doubt.
Well, my lords, when you read my supplementary case again, we address the Canadian jurisprudence and the relevant passages in Thompson are drawn out. But in fact, they're the very paragraphs that you find in the judgment of the Attorney General's reference case, because the same approach is taken in relation to documents. And perhaps if I might, with your Lordship's leave, take you if I can, to our supplementary case, which is in the supplementary bundle, just to make good this point. We address the Thompson newspaper's submission, if you like, at paragraph 8 of our supplementary case, page 9 of the supplementary bundle. And the relevant passages of Justice LaForest's judgment are set out in paragraph 10. Where he says this: for practical purposes, the subsequent use of such evidence, i.e. evidence that could not have been found by some other means, would be indistinguishable from the subsequent use of the pre-trial compelled testimony. In both cases, it can be said that the accused is being forced to answer a case that he or she was forced to make stronger than it would otherwise have been. And carried on, in my view, derivative evidence that could not have been found or appreciated except as a result of the compelled testimony under the Act should, in the exercise of the trial judge's discretion, be excluded, since its admission would violate the principles of fundamental justice. As will be evident from what I've stated earlier, I do not think such exclusion should take place if the evidence would otherwise have been found and its relevance understood. So you have the same principle being stated in the Thompson case in the context of documents, which was then given a more general, in my respectful submission, treatment in the Stillman case in 1997, 7 years later, and indeed by a larger composition of the court. Thompson, I think, had 5 justices and Stillman had 9. So, my Lord, that's why I took you to the Stillman case, because it's a more recent statement of the principle that you find in those passages in Thompson. My Lord, sorry, just to go back to my fourth reason, does that answer my Lord's question? My Lord Thompson's question on the Thompson point. Thank you, my Lord. So fourth, we submitted that too narrow a rationale has been applied, because if the rationale is the wider one of insisting that the prosecution must bear the entire load for making out its case, which is what the presumption of innocence is based on, and if it's also aimed at avoiding the use of undue coercion by the prosecuting authorities, then my Lord Kerr's point, made during my learned friend submissions, is the right one. If the material is incriminating, the degree of compulsion and the degree of pressure, psychological pressure that the individual is under is exactly the same, whether they're being asked questions or whether they're being compelled to hand over something which is incriminating. We submit, if we're right about that, then the consequences follow that I developed yesterday. Now, my lords, my lady, on this first question then of whether Article 6 is engaged at all, there are 4 points I'd like to address in my reply. The first one is the search warrant compulsory notice distinction, which my Lord Hodge was asking me about yesterday. The testimonial, non-testimonial distinction, which my learned friend still insists is one that you can find in the Strasbourg jurisprudence. Thirdly, whether the cruel trilemma constitutes sufficient psychological pressure to engage the privilege. And fourthly, whether only repeated use of such powers is necessary, or whether a single use of such powers is enough. Now, my lords, my lady, what is very clear in the jurisprudence from Saunders onwards is that documents or any other evidence that is obtained by means of a search warrant do not fall within the privilege against self-incrimination for the purposes of Article 6. And the court, you will find, rehearsing the paragraph 69 statement, paragraph 69 of Saunders' statement, in every case you will find that word documents is qualified by the words acquired pursuant to a warrant, except in one case, which is the L in the United Kingdom case, which we submit is an anomaly and is not to be followed. Why do the courts qualify it? Why is it a breach of the privilege to compel somebody to hand over documents under pain of punishment, but not a breach to compel them to open their door and to allow investigators to come in to carry out a search? And I mentioned yesterday in questions from my Lord Hodge the case of Bright and Lord Justice Judge's judgment, where he addresses precisely that question. And if I may take you to it now, it's it's volume 5 of the authorities bundle, tab 58, and then you'll find it on page 3581. And at E, halfway down the page 683 of the judgment, what Lord Justice Judge here was considering here was whether the use of a production order under section 9 of
Sorry, can you give me the tab number again?
Yes, my lord, it's volume 5, tab 58, page 3581.
Tab 58.
Sorry, I gather it's volume 6, but it's tab 58. I'm very grateful to my learned friend for putting me right.
Right.
So what the Court of Appeal, what the Divisional Court was considering in that case was whether a production order made in relation to a newspaper to obtain material for an investigation, whether that production order engaged the principle of the privilege against self-incrimination at common law. And he was comparing the power under Section 8 of the 1984 Act, which is the power of search and seizure, with the power under Section 9, which was the power to compel production of documents. And you'll see at E where he says this: with these principles in mind, I turn to Sections 8 and 9 of the 1984 Act, directed to the proper investigation of a serious crime after its commission, or more accurately, when there are reasonable grounds for believing that it's been committed, and involve the search for likely relevant and admissible evidence. These sections are directly concerned with the criminal process, and the search for incriminating material is in serious arrestable offences. That indeed is their exclusive purpose. Neither has anything to do with public administration. Under Section 8, a warrant to enter premises owned or occupied either by a suspect or someone against whom no hint of suspicion arises may be granted. If necessary, force may be deployed. During the course of the search, incriminating material may be seized, and if so, used at a subsequent trial. The privilege against self-incrimination is untouched. Of itself, the warrant does not permit a suspect to be questioned, and apart from permitting the entry and search, the individual in the premises, whether a suspect or not, is not required personally to assist or indeed do anything at all. He is entitled to remain entirely passive. By contrast, an order under Section 9 imposes a specific obligation, enforceable by a penal sanction, to produce or grant access to material which is likely to be relevant and admissible at a subsequent trial. It would be an odd and surprising development if the special procedure rules excluded the privilege against self-incrimination, where the same privilege is maintained in Section 8. At the risk of repetition, this permits the search of the premises, but does not require a suspect to produce incriminating material to the police or to give them access to it, although the police themselves may open doors and drawers as part of a legitimate search. Any admissible evidence is discovered by the searching officers, not handed over or made available to them under compulsion. Now, my lords, my lady, that is the distinction. That is why the privilege doesn't apply to a search warrant and never has.
I see what is there said, and I see there is a distinction. But if you're talking about psychological pressure to remain passive when others take incriminating material out of your files is maybe rather similar to the psychological pressure of you going to the files and taking the material out yourself.
Well, that's a very good reason, and I completely endorse the point that your lordship makes. That's a very good reason why the Canadian courts have gone further in protecting the privilege against self-incrimination.
But you're not suggesting that that is part of European human rights law?
Well, I can't. because paragraph
Do we know what the
69
Canadian courts say about search warrants?
what they say about search warrants. My understanding is all conscriptive evidence, which would include evidence obtained under a search warrant, which would obtain, which includes evidence obtained, I believe, under a search warrant.
When you say you believe, I mean,
Well,
Is that based on Stillman?
on Stillman? Yes.
I mean, the
Stillman's a DNA
problem is
case.
Stillman was a case in which Article 24 of the Criminal Code forbade the obtaining of material by a search in the way that was actually done. Now, if there is a specific right in Canadian law, as I assume that there is, to issue search warrants and to search premises, then that particular reasoning is not going to be of much relevance.
it'd be
I'll
odd,
find an
wouldn't
answer to the question in relation to search warrants, whether they are also included within this concept of conscriptive evidence and provide your lordships with it. My point, the reason why I took you to Stillman and to Thompson was firstly to show that it does not support the proposition for which it was employed, either by my learned friend or by any of the courts who have followed it, because the proposition for which it was employed was to say that the privilege doesn't apply to documents at all, whereas in fact what it provides authority for is that the privilege does apply to documents unless you would be able to obtain those documents by some other means.
I mean, I understand why you referred, but it would be a bit odd if under Canadian law you didn't have some means of obtaining material by a search warrant, which you couldn't then use, unless you could use it in a subsequent trial.
Let me find an answer to that question for your lordships. I'm sorry that I can't answer it at the moment. But the point is that distinction that the Canadian courts have gone down of saying, well, it depends on whether you can obtain it or not, is not a distinction that you find in the United Kingdom or Strasbourg authorities. But secondly, I could not stand before your lordships and say in a search warrant case that my client's privilege against self-incrimination has been breached. I couldn't do it as a matter of Strasbourg law, but nor could I do it as a matter of UK law. And I mentioned yesterday Lord Wilberforce's speech in the Rank film case. Can I just show you, your lordships, the passage? It's volume 2, tab 20, at page 2158. Turn back to page 2157 at the bottom of the page, where Lord Wilberforce set out the orders that were being challenged, the Anton Pillar orders. The first one required the respondents to supply information. 2157, my lords, lady. Bottom of the page at H. Thus, for present purposes, the orders fall under three heads. 1, requiring the respondents to supply information. 2, requiring the respondents to allow access to premises for the purpose of looking for illicit copy films and to allow their being removed to safe custody. And 3, requiring the respondents to disclose and produce documents. And then this, the orders under 2 were upheld by the Court of Appeal, and this part of the Court's decision was not seriously contested in this House. In any event, I'm satisfied that there was jurisdiction to make these orders and that the privilege against self-incrimination has no application to them. And my lords, there's another case in which the same point is made, the CPLC and P
But
judgment.
it's the same point. You can't do
I don't
better.
need to take
You can't
you
do
to
better than Lord Wilberforce.
Well,
Thank you, my lords.
Nobody disputes that the search warrants. The question is, what implications does that have for the wider principle which we are being asked to apply?
I understand the point, my lord, and it wasn't one clearly that bothered Lord Wilberforce in the Rank Films case, because they then went on to find that it would be a breach of the privilege against self-incrimination to require the defendants to comply with order number 1, which was the one requiring them to supply information. And that is why there is, it's been said, a trilogy of cases, and in fact, as I'll point out, there's in fact 5 House of Lords cases where it's been said in terms, without any question or qualification, that the privilege against self-incrimination at common law applies to documents. And my lords, that is a rule that is obtained in this jurisdiction for hundreds of years, and therefore it's a little bit odd if we should be questioning why the Strasbourg court has adopted the same approach. My lord, so that's why the search warrant point made by my learned friend in reliance upon the Calneniene case is nothing to the point. Calneniene is a case that falls squarely within paragraph 69 of Saunders, because it said in terms that documents acquired pursuant to a warrant do not acquire the protection of the privilege against self-incrimination. My lords, as to the testimonial, non-testimonial distinction, and maybe I'll be able to take this relatively quickly as far as the Strasbourg jurisprudence is concerned, because I took you yesterday to Jallow, paragraph 110, where the court specifically said, we know that there are some jurisdictions which apply this distinction, but we don't. But, my lords, nor is that distinction made at common law. And can I just take you to what Lord Justice Lawrence Collins, as he was, said in CPLC and P about this. It's page 1974, volume 1, tab 13. That was a case, my lords, in which the majority...
Can I just remind you, this is a reply.
I'm sorry, my lord, yes.
I'm not going to stop your taking us to this passage, because it's been referred to many times. I think we've all read it in your case. But you are referring us to quite a lot of authorities which we haven't looked at before, and that's not the function of a reply.
I apologise if there's anything that crops up which might take my learned friend by surprise. These are points made in my written case. But this is on this question. My learned friend does persist in a submission that there is a testimonial, non-testimonial distinction in Strasbourg. I've made my submission about that. All I wanted to draw your lordship's attention to is what Lord Justice Lawrence Collins said about the existence of such a distinction at common law. And paragraph 63 on page 1974, he has recited the Rank Films judgment, the Rio Tinto Zinc judgment, and earlier in his judgment he has looked at the Canadian authorities which do bring out this testimonial, non-testimonial distinction. But he was in the minority here in ruling that the Court of Appeal could not depart from the UK authorities. And he said this court is of course bound by these decisions, and I would hesitate at this appellate level to distinguish all three of the decisions of the House of Lords on the basis that they involved a testimonial obligation to disclose and verify documents, and to hold that the principles enunciated in those decisions do not apply to the compulsory production of pre-existing documentary evidence. First, there's almost no trace of this distinction in the decisions, apart perhaps from Lord Wilberforce's reference in Westinghouse to the difference between the risk of self-incrimination in the case of the validation of documents by sworn evidence on the one hand, and that in the case where the documents were simply pieces of paper found in a file. But Lord Wilberforce was only speaking of the risk of self-incrimination. Second, to draw a distinction between the testimonial obligation to produce and verify on the one hand, and the obligation to produce pre-existing evidence, would not give any weight to the reference in section 14 of the Civil Evidence Act to the right of a person in civil proceedings to refuse to produce any document or thing. And third, it's been emphasised that inroads into the privilege are primarily matters for Parliament. My lords, again, the reason I take you to the common law position is because it reinforces the position in Strasbourg. The Strasbourg court doesn't draw that distinction, nor do the UK courts, and we respectfully submit Lord Justice Lawrence Collins was correct in the CPLCP and P case in finding that the court should follow the UK authorities and that the majority were in error. And my lords, Lord Justice Collins' mention of section 14 of the Civil Evidence Act brings out another point which is made in my supplementary case, but I didn't deal with in my oral submissions yesterday because of the pressure of time. And if I may just draw out the point with your lordship's leave. But what Section 14 of the Civil Evidence Act does is that it, and my lords can have a look at it, it's volume 5, tab 41, page 2975. What it does is it doesn't expressly create the privilege against self-incrimination. It proceeds on an assumption that the privilege against self-incrimination exists at common law. It says the right of a person in any legal proceedings other than criminal proceedings to refuse to answer any question or produce any document or thing, if to do so, would tend to expose that person to proceedings for an offence or for the recovery of a penalty, and then limits it, says shall only apply to an offence in the United Kingdom, and then extends it to spouses. But the point is that Parliament legislated in Section 14 on the assumption that documents were included in the common law right. And my lords, there are two other, in fact more than two, but two in particular I draw your lordship's attention to, UK statutes that do exactly the same thing. The Inquiries Act 2005, Section 22, and the Coroners and Justice Act 2009, Schedule 5, Paragraph 2. They both state in terms that a person cannot be compelled to either give evidence or produce documents if they could not be compelled to do so in civil proceedings. And my lord, you find the same assumption made in Jersey legislation as well. And I mentioned yesterday, my learned friend mentioned it as well, the Criminal Justice International Cooperation Jersey law, which again proceeds on an assumption that there is a privilege against self-incrimination in relation to documents. It's Article 5A, and for your notes, Volume 4, tab 33, page 2668. My lords, psychological pressure. Is it enough simply to be placed in the cruel trilemma to fall within the concept of psychological pressure that engages the privilege against self-incrimination? We respectfully submit that the Strasbourg Court has proceeded on the assumption that the self-incriminating questioning of a criminal suspect of itself crosses that threshold and indeed is enough to destroy the very essence of the right.
How do you apply psychological pressure to a company? Accused and a company whose agents may or may not be.
Although you'll be aware that our case is that the compulsion operates upon the directors and officers of the company who represent the company.
They are not personally been charged in the sense that that word is used in the is the psychological pressure on them relevant?
I accept that if this were a case where there were no individuals who were suspected of criminal offending, then that would be a question which might cause me some difficulty if there wasn't an answer to it. So my first point to make is that this is a case where it's the directors and officers of the company. They are persons charged, yes. There's no doubt about that. It is an issue for the board to determine because the commissioner only accepted that Volaw were charged. But you've heard from my learned friend, he's referred to evidence that was given in the Bergen trial by directors of Volaw who had acted as directors of the companies. Again, I agree that if there had been an acceptance that Article 6 was engaged in relation to documents, there would have needed to have been perhaps a far closer scrutiny of the question of exactly who was charged and in relation to what. But the proceedings below proceeded on the basis that in fact Article 6 wasn't engaged at all, and therefore there was relatively little concentration on this question. However, we firstly have Commissioner Bellos finding that Volaw was a suspect. Secondly, I took your lordships to the Norwegian tax authorities' requests, which contain requests for information in relation to those persons who were directors and officers of the 9 appellant companies. And you have it's agreed between the parties that Volaw provided directors from among its own directors and officers of those companies. And you've heard from my learned friend that what they want to investigate arises from evidence that was given by those directors in the Norwegian proceedings in relation to their actions as directors of those companies. So for the purposes of this appeal, my lord, very sensibly perhaps the defendants, the respondents have proceeded on an assumption that the appellants are charged, and we respectfully submit that that is the correct assumption.
I suppose you would say that if the directors and officers of the company would come under psychological pressure by the revelation or the disclosure of these documents, you can't circumvent that by saying that the company doesn't have a psyche on which a pressure can be exerted.
That would be my answer if I thought of it.
It's very easy from here to think of these.
My lord, that's my answer to my lord's question, which would have saved us all 5 minutes. So, my lords, but the question is putting, if I may, with my Lord Sumption's forgiveness, put that question to one side. That is my answer. The question is, does the asking of the question, under pain of punishment, in the context of a criminal investigation, of itself amount to psychological pressure that engages the privilege? And the answer to that is clearly yes, and not only does it engage it, but it breaches the privilege. And I'll just, if I may, take you to 2 authorities and then give you citations for the other ones. I took you yesterday to Allen at paragraph 50, so I won't take you to that. That's where the court talked about pressure that overbears the will of the person. It's volume 13, tab 136, so volume 13, tab 136, and it's at paragraph 50. Murray, I took you to yesterday, paragraphs 49 to 50, volume 8, tab 84, page 4339.
Sorry, 4339.
4339. Shannon, paragraphs 38, 41, volume 8, tab 87, 4452. Martinen and Finland, paragraph 73, volume 3, 28, page 2563. And then the 2 authorities I would like to take you to, which I didn't show you yesterday on this point, are Heaney.
Heaney has gone into in some detail in the written cases.
Again, I'll give you the references in that case, my lord. It's paragraphs 48, 55 and 58. And my lords, I won't take you to it, but it's Van Weerelt.
Well, you took us to that yesterday.
Paragraph 55.
You gave us paragraph 60 and 62 in particular.
Yes, on this point it's paragraph 55. And it's volume 3, tab 30, 2632. And my lords, what we respectfully submit again is that on this point, Strasbourg merely reflects the very same privilege and protection that the common law has provided and we respectfully submit that comes out loud and clear from the passage in Murphy referred to in Brannigan and Davison. It's imposing upon somebody the cruel trilemma of perjury, self-incrimination, or contempt. And then the last point to make in relation to the applicability of Article 6 is this question of repeated versus single incidents of pressure. And there was a number of interventions from the board where my learned friend was on his feet, asking the question perhaps rhetorically whether cases like Funke in France and JB can be categorized as only authority for the proposition that you need repeated requests rather than a single request. Now that submission was made in the Heaney case and was rejected by the Strasbourg court at paragraph 49.
The state has acted oppressively, and multiple applications are simply one way in which, in certain circumstances, the state can act oppressively. I don't think it was suggested that the number of occasions was in itself the acid test.
In that case, my submission is this, that the Strasbourg jurisprudence does not use a test of oppression. What it uses is a test of coercion that overbears the person's will or in defiance of the person's will. So that is what engages the privilege. You do not need to show that the behavior is in some other way as well oppressive, because the very act of asking, of imposing the duty that creates the cruel trilemma is what creates the duty and the right under Article 6. But I've made the point that it doesn't require more than one request. So then, my lords, the question is, what do? You have my submission about that you should allow the appeal regardless of your view of the balancing exercise. I submitted that in any event, if you go on to consider that question, the absence of any notification and an opportunity to raise the privilege at an early point was itself a breach, not a point that my learned friend has responded to. And then in relation to the use immunity question, my learned friend submits essentially that, look, if there were to be a use immunity, firstly, he says, that puts the cart before the horse. He says, we shouldn't have to consider whether to give a use immunity until we've seen whether the material is incriminating or not. Well, my lords, that, with the greatest of respect, would be an entirely useless way of protecting the privilege against self-incrimination. The whole idea of the privilege against self-incrimination is that it prevents somebody from providing information that is or may be incriminating. Now, I accept that there is a way of asking compulsory questions in the context of an investigation, including a criminal investigation, if a sufficient safeguard is provided to avoid any breach. And now, the only sufficient safeguard that can possibly exist is if Article 6 does cover documents. So I've obviously got to have satisfied you on that question. But the only way in which that can be done is by way of an enforceable use immunity. That's my submission. Now, my lords, it's helpful to consider how this has been approached in other contexts, and I'll just make the point in relation to the common law. In both the Rio Tinto cases and the Rank Film cases, the argument being run by the plaintiff, the appellant, was that the court could sufficiently protect the privilege against self-incrimination by introducing a use immunity. And the House of Lords in both cases held in terms that they could not least because there wasn't an equivalent of Section 31 of the Theft Act. It wasn't until AT&T and Istel and Tully that the House of Lords held that they could create a use immunity. And that indeed was the outcome of the decision in Tully, that there had been an undertaking given by the prosecution not to use the documents in any subsequent criminal prosecution, and therefore there was no breach of the privilege. My Lords, that is the same approach that the courts, that Parliament has adopted when it has chosen to remove the privilege. And I mentioned yesterday the Theft Act 1968, Section 31, and Section 72 of the Superior Courts Act, and Section 13 of the Fraud Act 2006, all of which create a right that has been interpreted by the courts as including a right, a use immunity in relation to both answers and questions. And I mentioned the case of Bank of England and Riley, and that was the case where Mr. Justice Morritt, as he then was, held that Section 31 essentially created that use immunity. And all we submit, my Lords, is that the same approach is taken in Strasbourg. I mentioned Van Weerelt, I mentioned Martinen, both of which had different outcomes because of the absence in one and the presence in another of an acceptable use immunity. And while we do accept that Parliament has, in some legislation, restricted the privilege against self-incrimination and has only compensated for that restriction by a use immunity in relation to statements, it's our submission that those restrictions on the use immunity were introduced on the basis of an erroneous understanding of Saunders. And I mentioned the Youth Justice Criminal Evidence Act 1999, which was the legislation that introduced all the amendments. And I've put in your bundles the explanatory notes to the 1999 Act, which make that crystal clear. And if I can give your Lordships the reference, it's volume 16, tab 156, page 6956. And if we're right about the proper interpretation of Saunders, then we respectfully submit the answer is that you cannot put weight on the balance that Parliament has struck if Parliament struck it on the basis of a misunderstanding of the Strasbourg law. My Lords, the last point I would like to make, if I may, my learned friend refers to special features of Jersey which warrant a different approach. And he referred to the OECD model convention and commentaries, and was rather dismissive of those commentaries as not being relevant to Jersey. My Lords, if there is a case for saying that Jersey is a special case and that the concerns of Jersey are so widespread and justified as to warrant the removal of a fundamental right, which would not be warranted in another jurisdiction, then that's precisely the sort of issue upon which there needs to be evidence heard by a court that is being asked to carry out the balancing exercise for itself. Now, of course, it would be perfectly open if your Lordships find that the legislation is incompatible insofar as it gives no weight or consideration to the privilege in relation to documents for the states of Jersey to then go back and to consider its laws. And if they decide, well, actually, we've now considered the issue, and as legislators, we've decided to either wholly exclude or to provide some circumstances in which a use immunity is necessary and certain circumstances in which it's not necessary. Those are precisely the sort of questions that legislators are well equipped to answer. But this board, without any evidential foundation, cannot, with the greatest of respect, decide that Jersey needs to be treated as a special case. And if it is the case that Article 6 protects documents, and if it is the case that a use immunity will be required in all but the most exceptional circumstances, then the court should say so. And while that may well require amendments to legislation both in Jersey and in the United Kingdom, if your Lordships decide that your judgment should also have effect here. In the meantime, it's for the courts to craft a suitable remedy, and it's the remedy which we sought in these proceedings, which is that the courts can and should, if an order is to be, if a compulsory notice is to be complied with, allow it to be complied with only on conditions of a use immunity in relation to whatever is obtained. My Lords, unless I can be of any further assistance, those are my submissions.
Thank you very much, Mr. Byrne.
I'm conscious I didn't develop any of the other grounds, but I think I did specifically adopt them from my written case.
Yes. In fact, we've all read them, and I'm satisfied we can deal with them on the basis of the material that we have in the written cases. Well, the board is grateful to both counsel and also to those sitting behind counsel who have been involved in preparing the cases. This is obviously an important and interesting appeal, and we will take time to consider carefully all that we've heard before we decide what advice we will tender to Her Majesty. Court will adjourn.